June 3, 1961, Panama City, Florida. A 50-year-old drifter named Clarence Earl Gideon stands in a circuit court. No tie, no attorney. Just a man standing alone before a judge to face burglary charges. He has no money to hire a lawyer. He asks the court to appoint him one. The judge refuses. Under Florida state law, a grown man committing a simple, non-capital felony does not qualify for free counsel. He is forced to defend himself against a trained prosecutor. The evidence is thin, a single witness, but the trial takes less than an hour. The jury convicts him in exactly 53 minutes. The judge hands down a 5-year prison sentence. The system did not malfunction that day. It functioned exactly as designed. The legal machinery processed an unrepresented man with ruthless efficiency. The Sixth Amendment of the United States Constitution is entirely direct. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel. But for most of the 20th century, that absolute guarantee carried a massive, invisible asterisk. In 1942, the Supreme Court ruled in a case called Betts v. Brady. That decision meant state courts did not automatically have to provide lawyers to the poor. The ruling created a condition known as the Special Circumstances Doctrine. A state only had to appoint an attorney if a case was uniquely complex, or if the defendant was intellectually disabled. Ordinary men had to navigate the courtroom alone. The court assumed that ordinary people could handle an adversarial legal trial without training, or it simply relied on the fact that an uneducated citizen lacked the resources to challenge the bureaucratic machinery once the gavel fell. Judicial convenience and volume were prioritized over individual defense. This created a 20-year gap between what the Constitution promised and what American cormorants actually delivered. Gideon is sent to Florida State Prison. Most men serving time for petty theft keep their heads down and count the days. Gideon goes to the prison library. He finds the legal reference volumes and he starts reading. He is not a scholar. He never finished the 9th grade. But that lack of formal academic training becomes a distinct asset. He is not weighed down by complex legal theory. He reads the rules with a raw, literal interpretation. This diagram shows what he found. On one side is the absolute plain text of the Sixth Amendment. On the other, the conditional rules of the 1942 Supreme Court ruling. There is a glaring friction point. The Constitution makes absolutely zero mention of special circumstances. The requirement for special circumstances was a judicial invention, an elite layer of interpretation artificially stacked on top of a foundational document. An uneducated prisoner used stubborn reading comprehension to mathematically locate a structural failure in the highest court of the land. He decides to attack the precedent directly. He drafts a petition to the Supreme Court. He files it in forma pauperis, a Latin provision allowing impoverished inmates to bypass standard filing fees and strict formatting requirements. It is 5 pages long, written in pencil. There are misspellings, words are crossed out. It is a humble, unpolished document proposing a massive legal override. The Supreme Court receives the handwritten letter. The justices review it, and they recognize that their 20-year precedent is broken. To formalize Gideon's logic, they appoint one of the most accomplished appellate lawyers in the country, Abe Fortas, to argue his case. The justices vote 9-0, unanimous. They overturn Betts v. Brady. The court declares that in a criminal trial, defense lawyers are a strict necessity, not a conditional luxury. A single act of writing from a concrete cell forced the most calcified legal institution in the country to admit a historical error and correct itself. August 1963. The experiment runs again. The exact same courthouse, the exact same defendant, the exact same burglary charge. Only one variable has been modified. This time, Gideon sits next to a court-appointed defense attorney named W. Fred Turner. Turner applies mechanical friction to the prosecution's case. He aggressively cross-examines the state's only witness. He probes the timeline. He questions the lighting. He asks exactly where the witness was standing outside the pool hall at that hour. Then, Turner introduces a devastating alternative theory. He suggests the witness himself was the actual lookout. It instantly shatters the smooth, unopposed narrative the state relied on 2 years earlier. This retrial is the ultimate empirical proof. A constitutional right remains purely theoretical until a competent defender uses it to apply physical friction to a prosecutor's case. The jury deliberates for barely an hour. Not guilty. Gideon walks out of the courthouse a free man, having lost 2 years of his life in a concrete cell for a crime the state could not prove. The verdict triggers an immediate systemic reaction. Florida is forced to review thousands of previous convictions. Nationwide, the ruling forces the creation of the modern public defender infrastructure. But the repair does not extend to the man himself. Gideon cannot escape the grinding systemic poverty that made him a target in the first place. He dies penniless. He is buried in an unmarked grave. The man faded, but the specific tool he used remains. Today, that 5-page handwritten petition is preserved in the National Archives. Institutional machines never willingly reform themselves. They demand efficiency. They prioritize volume. To stop them, an ordinary individual has to physically wedge themselves into the gears and refuse to accept that efficiency equals justice.